What is the Texas Lawyer's Creed and why is it important? The Texas Lawyer's Creed is a declaration of professionalism and civility issued in 1989 by the Texas Court of Criminal Appeals and the Texas Supreme Court. It is a statement of the ethical principles that all lawyers in Texas are expected to uphold. The creed consists of 4 parts. The first part is our legal system. A lawyer owes to the administration of justice personal dignity, integrity, and independence. The second part, lawyer to client. A lawyer owes to a client allegiance, learning, skill, and industry. 3, lawyer to lawyer. A lawyer owes to opposing counsel in the conduct of legal transactions, in the pursuit of litigation, courtesy, candor, cooperation, and scrupulous observance of all agreements and mutual understandings. The fourth part, lawyer and judge. Lawyers and judges are equally responsible to protect the dignity and independence of the court and the profession. The Texas Lawyer's Creed is important because it provides a framework for lawyers to uphold the highest standards of professionalism and civility. It is a reminder that lawyers have a duty to the public, to their clients, and to each other. The Creed has been cited in a number of cases by the Texas courts, and it has been used to discipline lawyers who have violated its principles. It is a valuable resource for lawyers in Texas, and it helps to ensure that the legal profession is held to the highest standards. Here are some of the benefits of upholding the Texas Lawyer's Creed. 1, it promotes trust in the legal profession. When lawyers behave in a professional and civil manner, it shows that they are committed to upholding the law and serving the public. This helps to build public trust in the legal system. The second benefit, it creates a more harmonious and productive work environment. When lawyers treat each other with respect, it creates a more pleasant and productive work environment. This can lead to better outcomes for clients in the legal system as a whole. The third benefit, it protects the integrity of the legal system. When lawyers violate the principles of the Texas Lawyer's Creed, it can undermine the integrity of the legal system. This can make it more difficult for people to get justice, and it can erode public confidence in the law. The Texas Lawyer's Creed is an important document that helps to uphold the highest standards of professionalism and civility in the legal system. It is a valuable resource for lawyers in Texas, and it helps to ensure that the legal system is fair and just for everyone. Okay, so now I'm going to go ahead and read the Texas Lawyer's Creed. It is a mandate for professionalism and was promulgated by the Supreme Court of Texas and the Court of Criminal Appeals on November 7th, 1989. And here it goes. I am a lawyer. I am entrusted by the people of Texas to preserve and improve our legal system. I am licensed by the Supreme Court of Texas. I must therefore abide by the Texas disciplinary rules of professional conduct. But I know that professionalism requires more than merely avoiding the violation of laws and rules. I am committed to this creed for no other reason than it is right. Okay, now I'm going to go into the first part, our legal system. A lawyer owes to the administration of justice personal dignity, integrity, and independence. A lawyer should always adhere to the highest principles of professionalism. 1, I am passionately proud of my profession, therefore my word is my bond. 2, I am responsible to assure that all persons have access to competent representation regardless of wealth or position in life. 3, I commit myself to an adequate and effective pro bono program. 4, I am obligated to educate my clients, the public, and other lawyers regarding the spirit and letter of this creed. 5, I will always be conscious of my duty to the judicial system. Okay, that was our legal system. Now I'm going to talk about lawyer to client. A lawyer owes to a client allegiance, learning, skill, and industry. A lawyer shall employ all appropriate legal means to protect and advance the client's legitimate rights, claims, and objectives. A lawyer shall not be deterred by any real or imagined fear of judicial disfavor or public unpopularity, nor be influenced by mere self-interest. 1. I will advise my client to the contents of this creed when undertaking representation. 2. I will endeavor to achieve my client's lawful objectives in legal transactions and in litigation as quickly and economically as possible. 3. I will be loyal and committed to my client's lawful objectives, but I will not permit that loyalty and commitment to interfere with my duty to provide objective and independent advice. 4. I will advise my client that civility and courtesy are expected and are not a sign of weakness. 5. I will advise my client of proper and expected behavior. 6. I will treat adverse parties and witnesses with fairness and due consideration. A client has no right to demand that I abuse anyone or indulge in any offensive conduct. 7. I will advise my client that we will not pursue conduct which is intended primarily to harass or drain the financial resources of the opposing party. 8. I will advise my client that we will not pursue tactics that are intended primarily for delay. 9. I will advise my client that we will not pursue any course of action which is without merit. 10. I will advise my client that I reserve the right to determine whether to grant accommodations to opposing counsel in all matters that do not adversely affect my client's lawful objectives. A client has no right to instruct me to refuse reasonable requests made by other counsel. 11. I will advise my client regarding the availability of mediation, arbitration, and other alternative methods of resolving and settling disputes. Okay, now lawyer to lawyer. A lawyer owes to opposing counsel in the conduct of legal transactions and the pursuit of litigation courtesy, candor, cooperation, and scrupulous observance of all agreements and mutual understandings. Ill feelings between clients shall not influence a lawyer's conduct, attitude, or demeanor toward opposing counsel. A lawyer shall not engage in unprofessional conduct in retaliation against other unprofessional conduct. 1. I will be courteous, civil, and prompt in oral and written communications. 2. I will not quarrel over matters of form or style, but I will concentrate on matters of substance. 3. I will identify for other counsel or parties all changes I have made in documents submitted for review. 4. I will attempt to prepare documents which correctly reflect the agreement of the parties. I will not include provisions which have not been agreed upon or omit provisions which necessarily reflect the agreement of the parties. 5. I will notify opposing counsel and, if appropriate, the court or other persons as soon as practicable when hearings, depositions, meetings, conferences, or closings are canceled. 6. I will agree to reasonable requests for extensions of time and for waiver of procedural formalities, provided legitimate objectives for my client will not be adversely affected. 7. I will not serve motions or pleadings in any manner that unfairly limits another party's opportunity to respond. 8. I will attempt to resolve by agreement my objections to matters contained in pleadings and discovery requests and responses. 9. I can disagree without being disagreeable. I recognize that effective representation does not require antagonistic or obnoxious behavior. I will neither encourage nor knowingly permit my client or anyone under my control to do anything which would be unethical or improper if done by me. 10. I will not, without good cause, attribute bad motives or unethical conduct to opposing counsel, nor bring the profession into disrepute by unfounded accusations of impropriety. I will avoid disparaging personal remarks or acrimony towards opposing counsel, parties, and witnesses. I will not be influenced by any ill feeling between clients. I will abstain from any allusion to personal peculiarities or idiosyncrasies of opposing counsel. 11. I will not take advantage by causing any default or dismissal to be rendered when I know the identity of an opposing counsel without first inquiring about that counsel's intention to proceed. 12. I will promptly submit orders to the court. I will deliver copies to opposing counsel before or contemporaneously with submission to the court. I will promptly approve the form of orders which accurately reflect the substance of the rulings of the court. 13. I will not attempt to gain an unfair advantage by sending the court or its staff correspondence or copies of correspondence. 14. I will not arbitrarily schedule a deposition, court appearance, or hearing until a good faith effort has been made to schedule it by agreement. 15. I will readily stipulate to undisputed facts in order to avoid needless costs or inconvenience for any party. 16. I will refrain from excessive and abusive discovery. 17. I will comply with all reasonable discovery requests. I will not resist discovery requests which are not objectionable. I will not make objections nor give instructions to a witness for the purpose of delaying or obstructing the discovery process. I will encourage witnesses to respond to all deposition questions which are reasonably understandable. I will neither encourage nor permit my witness to quibble about words where their meaning is reasonably clear. 18. I will not seek court intervention to obtain discovery which is clearly improper and not discoverable. 19. I will not seek sanctions or disqualification unless it is necessary for protection of my client's lawful objectives or is fully justified by these circumstances. Okay? Now I'm going to go into lawyer and judge. Lawyers and judges owe each other respect, diligence, candor, punctuality, and protection against unjust and improper criticism and attack. Lawyers and judges are equally responsible to protect the dignity and independence of the court and the profession. 1. I will always recognize that the position of judge is a symbol of both the judicial system and administration of justice. I will refrain from conduct that degrades the symbol. 2. I will conduct myself in court in a professional manner and demonstrate my respect for the court and the law. 3. I will treat counsel, opposing parties to the court, and members of the court staff with courtesy and civility. 4. I will be punctual. 5. I will not engage in any conduct which offends the dignity and decorum of proceedings. 6. I will not knowingly misrepresent, mischaracterize, misquote, or miscite facts or authorities to gain an advantage. 7. I will respect the rulings of the court. 8. I will give the issues in controversy deliberate, impartial, and studied analysis and consideration. 9. I will be considerate of the time constraints and pressures imposed upon the court staff, and counsel in efforts to administer justice and resolve disputes. Okay, this mandate was mandated by the Supreme Court of Texas and the Court of Criminal Appeals on November 7th, 1989, and was reaffirmed by the Supreme Court of Texas and the Texas Court of Criminal Appeals in April 2013. Thank you so much.